Well, parents in agriculture often advance money to a child for a variety of reasons. However, there are often questions if an advance is a loan or if it's a gift. And that proper classification could make a big difference from a tax standpoint. Roger McEowen with the Washburn University School of Law joins us now for today's Rural Money segment. And Roger, as always, thanks for your time today. So what are some of the reasons a parent will advance money to their kids?
Well, good to be with you, Janet. There are probably innumerable reasons a parent might do this. They may have a child that has a particular financial need. They want to help them buy that first house or get a car or maybe acquire some farmland or something like that. But the reasons are as varied as children are. So there are a whole host of reasons why parents might do this.
So what is the IRS presumption on the matter?
Well, the issue that comes up, of course, is whether funds that are advanced to a child are a loan or is it a gift. And that really comes to head when you have multiple children in the family and not all received advances, and then after the parents die, the money that hasn't been paid back, of course, the child that received the advance is claiming, well, that was a gift. I don't have to pay that back to the estate. And the other children may feel, well, no, mom and dad intended that to be a loan that you now need to pay back to the estate. And of course, they're going to benefit in that if it comes back to the estate. So the presumption by IRS is that it is a gift when a transfer is between family members, and they have a whole host of factors that they go through to determine that. And basically, is it a bona fide debtor-creditor relationship? And if so, it's a loan. If you don't document it, it's probably going to be a gift.
So what would you say is the big takeaway that farmers and their kids need to keep in mind in this situation?
Well, the big takeaway was the reason I wrote on this recently is because of a recent case. This issue came up again. The big takeaway is just be careful when you're making loans or gifts to children. Take care to document the transaction carefully. Make sure to structure it within the IRS factors that they have. And basically, if it is to be a loan, treat it as a loan. Get it in writing. Make sure it is. Maybe you're going to secure it by collateral. Make sure payments are required. Make sure the child can make the repayments. Go through if you were getting money from a lender, just go through that same process that they would go through. But whatever you do, document your intent very carefully so that those that remain after you pass know exactly what your intent was, and that's the take home from today.
All right. Well, Roger, as always, thank you very much for your insight today. Roger McEowen, he's with the Washburn University School of Law on the phone with us today from Topeka, Kansas.